Good afternoon, everyone. This is Tina Matsuoka. I'm the Executive Director of NAPABA, and I want to thank you for signing up to participate in our third annual Lobby Day, which will take place in May during APA Heritage Month. This is one of the highlights of NAPABA's bar year, and your presence at Lobby Day is a critical factor in our efforts. So we really do appreciate and thank you for your participation. I'm going to give you a little bit of background. I want you to know that our policy work is driven by our committees who propose resolutions and our Board of Governors, which reviews and adopts the resolutions that will guide us throughout the bar year. All of these resolutions are available on our website for your review, www.napaba.org. We've selected 3 policy priorities for Lobby Day, and these are common sense immigration reform, voting rights, and judicial nominations. During today's webinar, you're going to hear from folks who will provide you with information about Lobby Day, basic how-tos about lobbying and meeting preparation, as well as background about each of our policy priorities. As a reminder, all participants have been muted during the call, but you can pose questions at any time in the Q&A feature of the webinar. You just click the Q&A button on the toolbar at the top of your screen and enter your question into the text field. At the end of the call, all the questions will be answered in turn. And if you're not using the webinar feature, you can email your questions to Melanie Robinson at mrobinson@napaba.org. And with that, I'm going to turn things to Melanie, who is our programs associate, and she has been coordinating Lobby Day and has been in touch with many of you, I know, already.
Hi, all. This year, Lobby Day is composed of 6 events: a webinar, an in-person training, the congressional reception, a welcome breakfast, member meetings, and a participant debrief and happy hour. The information provided during the webinar will be supplemented by handouts provided to participants on Lobby Day. The in-person training on Monday, May 20th from 5 to 6 p.m. will provide key logistical information, tips for lobbying, and provide time for participants to strategize with lobbying teams. The NAPABA APA Heritage Month congressional reception will directly follow the in-person training. Breakfast on Tuesday, May 21st will start at 8 a.m. at Jones Day. Participants will hear from speakers and meet in their lobbying groups. Lobbying groups will depart together for meetings. Participants will attend 3 to 4 meetings depending on their region and group. Staff schedule meetings for participants. Participants will be given their schedules at the training on May 20th. Participants are generally divided into groups based on region, with a leader for every group. After the meeting, participants will debrief with staff about their meetings and discuss follow-up steps. Refreshments will be served. We'll now hear from NAPABA Policy Director Emily Chatterjee, who will discuss the basics of lobbying.
Thanks, Melanie. Good afternoon, everyone. I just wanted to go over a couple basics about preparing for Hill meetings and the structure, what you can anticipate in terms of the structure of meetings. First, I want to let you know that you do not need any information beyond the materials that we were going to provide for you for these meetings. Participants are not expected to be experts in issue areas, and most importantly, we want you to incorporate your experiences as an attorney and as a member of the Asian Pacific American community into your asks when you have these meetings. And to the extent that it's relevant, tell stories about your personal experiences. If you know about, someone who has had an experience in immigration that illustrates a point that we're lobbying about, for example, that is extremely helpful when speaking to congressional staffers or members. Second, we're going to be providing you with a lot of different materials to help you prepare. That will include talking points about the policy priorities that we're going over today, as well as a chart that's going to list out the relevant positions taken by members who all of you are going to be meeting with that day to help guide you and prepare you and get a sense of what it is you should be expecting in a particular meeting. I also wanted to let you know there are different kinds of meetings that you can anticipate. Most meetings, particularly on the House side, are going to be with staff members who may be a lot younger than you might anticipate, and that's okay. These folks are experts in what they're doing, and they have direct relationships with the members. So, don't be taken aback if the staffer is particularly young. Just introduce yourself, and everyone should introduce themselves individually. And then, in particular, if you are a constituent, please identify that because that is particularly important to the member. As I said, most of these meetings are going to be with staff, but some of these meetings are going to be directly with members of Congress. And you should anticipate that those meetings might be a little bit different. There's probably going to be a photo op component of those meetings, and just anticipate that if that's part of it, then that's going to eat into the time that you have to talk about the specific policy, concrete stuff. Finally, you want to ask for specific actions in these meetings. If there's a specific ask on immigration or a particular piece of legislation, voting rights, or support in the Senate for a particular nominee, you want to the extent that you can, if you can, please remember to leave the leave behind. So that's all 14 of the policy priorities that NAPABA the NAPABA board has passed, so that the staff members in the entire office knows all of the different policy areas that NAPABA has taken a stance on, so that they can be in touch with us throughout the year if there are issues that they are, focusing on and legislation they're promoting that we can work with them on. And that's it. Thanks so much, Melanie.
Thank you, Emily. I'd now like to introduce the next presenters, Erin Oshiro and Jessica Chia. Erin Oshiro is the Senior Staff Attorney for the Immigration and Immigrant Rights Program at the Asian American Justice Center. Erin's current work focuses on advocacy concerning federal immigration policy and making sure that Asian American interests are represented in the immigration debate. Jessica Chia is a staff attorney in the Immigration and Immigrants' Rights Program at AAJC, where she engages in federal policy advocacy, litigation, and community education. Erin and Jessica will discuss comprehensive immigration reform.
Thanks, Melanie, for having us on the call. So as Melanie mentioned, Erin and I are staff attorneys at the Asian American Justice Center, which is a member of the Asian American Center for Advancing Justice. Just a little bit of background on our organization. We were founded in 1991, and we're a national civil and human rights organization, and our mission is really to advance the human and civil rights of Asian Americans and to build and promote a fair and equitable society for all. And in our immigration program, we're really engaged in the advocacy around comprehensive immigration reform. So as you're likely very aware, CIR is a very timely issue to be meeting with members of Congress for this year's NAPABA Lobby Day. For the first time since 2007, passage of CIR is again viable, in part because of the growth of the immigrant rights movement. And earlier this month, on April 16th, a bipartisan group of 8 senators introduced a much-anticipated comprehensive immigration reform bill titled the Border Security, Economic Opportunity, and Immigration Modernization Act, which we'll refer to as Senate Bill 744. The President has also said that passing immigration reform is a top priority for his administration this term, and we also understand that a bipartisan group of House members are also planning on introducing a bill in the next couple of weeks. So Asian American communities are really impacted by every facet of our nation's current immigration laws and by this bill. As the fastest growing minority group in the country, it's projected that our population will grow to approximately 40 million by 2050. Nearly 2/3 of us are foreign-born, and of the estimated 11.2 million undocumented people in the country, approximately 1 million of us 1 million are of Asian origin. So the 3 areas we're actually going to focus on for purposes of the lobby visits will be on family reunification, a path to citizenship for the undocumented, and interior enforcement, specifically E-Verify, which is a federal electronic employment verification system. Not because all of the components aren't important to us, but because for these issues specifically, there's a hugely disproportionate impact on Asian Americans, and because these are also some of the areas in need of the most improvement as the bill moves forward in Congress. Hi, Melanie, this is Erin. If you can move to the next slide. Good afternoon, this is Erin Oshiro. So I just want to talk a little bit about the family reunification piece of this section of the presentation. So the family immigration system is one of the main ways that people come to the U.S., and it's very important to the Asian American community in particular.
approximately 60%, as Jessica mentioned, about 60% of Asian Americans are foreign-born, and although we're only 6% of the U.S. population, we sponsor more than a third of all family-based immigrants. And you'll see here from the chart that is on the screen, your screens, that of the about 4.3 million family members who are in line for a family-based visa, so by and large these are folks waiting overseas to be with their family members in the U.S., nearly 2 million of them are Asian American, and the other greater numbers are for Latino immigrants. African immigrants are very impacted as well. You can see from the chart that 5 Asian countries are among the top 7 countries with the most family members waiting abroad. Next slide. So just to focus on Senate Bill 744, it was a mixed bag on the family piece in particular. There were a number of positive changes for the family system that we and other advocates were really excited to see. I know some of you may not be familiar with the immigration system or family-based immigration, so I'll try to explain some of this. But some of the good things in the bill would be over time the backlog of the 4.3 million people will be reduced. It'll be reduced over a period of 8 to 10 years, so it's not happening overnight. It's not happening tomorrow, but over time that will go away. The bill also does something with respect to green card holders or legal permanent residents. It would redefine the term immediate relative, which has special significance for immigration, to now include spouses and minor children of green card holders. This would basically put them on the same footing as the spouses and minor children of U.S. citizens, which mean that they are no longer subject to numerical caps and that they can reunite with their family members in the U.S. more quickly. So this is a very welcome change and will help, hundreds of thousands of families. It will also have some improvements other improvements for minor children. It would now allow the parents of U.S. citizens who immigrate to the U.S. to bring their own minor children with them. In essence, they would be bringing the minor brothers and sisters of U.S. citizens to the United States. Currently, they're not allowed to do that. Another change is that it would also allow some family members who are waiting for their green cards to wait here in the U.S., which would be a welcome change as well. But on the flip side, there are definitely many things about the Senate bill that we are very troubled about with respect to family. So just want to flag a couple items for you. So the Senate bill would eliminate the ability of brothers and of U.S. citizens to be able to petition for their brothers and sisters or adult married children who are over the age of 30. So it would place an age cap on that particular those family members. And this would be a change from our sort of long-standing tradition of promoting family reunification and keeping families together. So this would be a pretty drastic change, particularly for countries like the Philippines and India, who use those family categories, the brothers and sisters and adult married children, quite heavily to keep their families together here in the U.S. So we're very concerned about those changes. Another thing to flag is that the Senate bill does not make our immigration laws inclusive. It continues to exclude LGBT families from accessing our immigration system and for allowing LGBT families to make use of our family-based immigration system. This is something that we are troubled by. And the last thing, which is unique to our Asian American community, is it does not include a fix that targets Filipino American veterans. So these are elderly individuals who fought on behalf of the U.S. in World War II and have the same struggles to bringing their children to the U.S. that other countries face. Extremely long wait times. We're talking 20 years, 18 years to bring their children here to the U.S. To help take care of them and to be with them. So this is something that is not in the bill, but we are hopeful it would be added in the amendment process, something that Senator Hirono has championed on her own. The last thing I want to mention on the family piece is that the Senate bill does include a proposed merit-based or points system, which does provide a few points to applicants who are the siblings or these older adult married children of U.S. citizens. It basically gives them some points. The system also awards points for other criteria such as education, work experience, English skills. But we're very concerned that this system will not provide a realistic opportunity for those family members to come to the U.S. We really think it's potentially a system that really just sort of, advantages those who are the most educated, the ones who have the best English skills, and could disadvantage, family members who haven't had access to education abroad, particularly women, how it might impact them and hinder their ability to be in the U.S. Next slide. So you can see here, and I won't necessarily read these to you, but, these are some of the talking points that, we're hoping can be lifted up during the lobby days. I will say that things can change very rapidly because between now and when lobby day takes place, because the Senate Judiciary Committee starting next week will begin the process of amending the Senate bill. So the pieces on family and other issues could get better, could get worse, not really sure. But definitely we recognize the hard work that the Gang of Eight in the Senate put together in putting forth this bill. Family immigration is very important to our community. We're deeply concerned about the proposed changes to some of these family categories. And we are asking all members of Congress, from all backgrounds and affiliations to, make sure that our family immigration system is effective, efficient, and adheres to our American values of family unity. So I think that the lobby action will come at a really crucial time as we're finishing up the amendment process and looking forward to, a fight on the floor over this bill. Now I'm going to hand it back to Jessica to talk about path to citizenship.
So transitioning to our second issue, which is a component of CIR you've probably heard the most about in the media, AAJC is encouraged by the inclusion of a path to citizenship in the bill. Approximately 1.3 million, as I mentioned, of the 11 million undocumented immigrants in the U.S. are Asian Americans. So, this is a provision that would definitely benefit our communities greatly. So I'll talk a little bit about what the bill does and then some of our concerns next. So Senate Bill 744 permits certain undocumented immigrants to seek what they called Registered Provisional Immigrant Status, RPI status, in advance of becoming a legal permanent resident or green card holder and then later a citizen. Basic eligibility requires that one is present in the U.S. on the date of filing, present in the U.S. prior to December 31st, 2011. I'm going to talk about this date later when I talk about our concerns. Continuous presence since this date, except for brief, casual, and innocent departures, and you must also not have been convicted of certain criminal offenses. So the RPI status is granted for 6 years, and then it may be extended for another 6-year term if the individual remains eligible and meets the requirements for extension. After 10 years in this RPI status, the person would then be eligible to apply for LPR status. And then the person would have to be in LPR status for an additional 3 years before he or she may apply for citizenship. So there's a number of requirements that must be fulfilled to move on to each stage of the process. And there's also a number of border triggers for each of these stages. They're too kind of numerous to cover in this webinar, but basically before undocumented immigrants can enter into each of these statuses, there are certain metrics that DHS must meet. Next slide, Melanie. So as I mentioned, while AAJC is encouraged by the inclusion of a path to citizenship, there are a number of areas of concern that we and our affiliates have with the process and that we hope is going to be improved as the bill is marked up. And generally speaking, we think that the proposed 13-year path contains, a set of requirements that would unnecessarily exclude a significant number of people and really make it difficult for them to get to naturalize and get to the stage where they can become citizens. Many of us advocates also feel that the border triggers are unnecessary given that, as you may have heard, the border is already more secure than ever before. So more specifically, I'm going to go to kind of our first specific concern. We think that the requirement that in order to renew your RPI status and to adjust from RPI to LPR status, there's a requirement that an individual must demonstrate regular employment through the process, except for periods of not more than 60 days would be a really difficult barrier for people. A lot of aspiring Americans, they work in contingent jobs such as day labor, construction, and domestic work, where, these brief periods of unemployment are very regular, and it's not uncommon to not have work for these periods of time. So we think that requirement should be eliminated. Second, we think that the English language skill requirement to adjust from RPI to LPR status would also present a roadblock for many, including Asian Americans. Under current law, there is an English language requirement for naturalization, but not to obtain your green card. And so this requirement for RPIs would actually be a higher threshold. And we think it's, unnecessary because individuals would still have to meet that requirement in order to naturalize and gain citizenship. The English language requirement would impose difficulties for many. Many Asian Americans live in linguistically isolated households in which everyone over the age of 14 is limited English proficient. And obviously it's going to have large impacts on poor and low-income people who are not able to find free or low-cost English classes. So we think that this requirement should be eliminated as well. Moving on to our third concern, we think that the requirement that an individual who has to be physically present in the U.S. on or before December 31st, 2011 would, again, unnecessarily exclude people, and it really should be based on fairness and the idea that we want successful reform so that we don't have to revisit CIR again in the near future. Should be the date of enactment instead of this arbitrary date of December 2011, which is going to exclude a lot of people from eligibility. And then lastly, I know I've gone on for a while, we would like to see that the one-year period for applying for our RPI status be extended to at least 3 years, if not 5 years. This one-year period really doesn't provide sufficient time for a lot of people who are going to be seeking to legalize their status. It also creates a lot of barriers and difficulties for organizations that are going to be working on informing and educating and assisting millions of potential applicants. And we think that this insufficient time is also going to make potential applicants really vulnerable, to unscrupulous operators who are, likely going to use this one-year application deadline to take advantage of people. So we think that this period should be extended as well. So these are just a few improvements that we think we should be advocating for. And then I think we're going to go on to the next slide to talk about our last point, which is E-Verify.
5 minutes remaining.
Great. Thanks. This is Erin again, and I will keep this brief, so thanks for the reminder. So the last item we wanted to touch on with regards to immigration is electronic verification, or E-Verify. So the Senate bill would require, so you'll see here, so E-Verify is is currently a voluntary federal electronic employment eligibility verification system. Basically allows employers who use the E-Verify program to make sure that a prospective worker has legal authorization to work in the U.S. But the program is not without flaws, the existing program, and we think that would have a disproportionate impact on Asian American workers as well as business owners. And we're particularly concerned if the program is made mandatory. Some of the studies that have been done on E-Verify so far, have found that there are much higher error rates for foreign-born workers. One study found that the error rate was 20 times higher for foreign-born workers versus U.S.-born workers. And we should just keep in mind that there are more than 8 million Asian American foreign-born workers in the U.S. So it's really, it could be particularly troublesome for our community to, experience, the impact of this program if it's made mandatory. And the concern is that, we need to have robust due process protections put in place if this program is expanded to all employers, to make sure that workers who get hits in the system suggesting that they are not legal, that are not authorized to work, are able to clear up those errors as quickly as possible so that they're not adversely impacted, that they don't lose wages, that employers, don't let them go unnecessarily, that they are not discriminated against in the process. And I think on the, side of employers, we need to think about how does this impact, for example, small businesses, because the Senate bill doesn't include any exceptions for very small businesses. So they will all have to basically have the capability of accessing this system to check, every new employee that they want to hire. So this includes all the moms and pops. We know that for business owners and workers who might not be English proficient, who might not have the infrastructure necessary to support this kind of a program, it could be very costly and burdensome for them to have to comply, with E-Verify. So we're definitely concerned about, how this will impact our community, both from a business and a worker perspective, and hope that as the bill moves forward, that the protections from a due process perspective will be strengthened as much as possible to lessen the harmful impact. And I think, is there one more slide? I think that might be it. So that covers everything, I think, for us, and happy to answer questions at the end.
Great. Thank you, Erin and Jessica. I just want to take the time to remind everyone about the question and answer feature located at the top of your screen. So if you have a question about lobbying or about any of our policy issues, please go ahead and enter that in on the Q&A feature. Now I'd like to introduce our next presenter, Glenn Magpantai. Glenn Magpantai is the director of the Democracy Program at the Asian American Legal Defense and Education Fund. His practice at ALDEF includes the enforcement of the Federal Voting Rights Act with regards to bilingual ballots and redistricting, access to the vote, Asian American political opinion, and census public education, advocacy, and monitoring. Glenn will discuss voter rights.
Thanks so much, and thanks to Tina and the whole team at NAPABA. The Asian American Legal Defense Fund is so proud to have partnered with NAPABA both last year and many years and many NAPABA affiliates to monitor elections in a number of jurisdictions to ensure that they fully comply with the Federal Voting Rights Act and the Help America Vote Act. The last election, NAPABA and ALDEF and the affiliates collaborated to send over 800 volunteers into 15 states to monitor the voting process and to make sure that that Asian American voting opinion was fully revealed. And one of the great findings that we found is a tremendously large support amongst Asian American Republicans and Asian American Democrats for comprehensive immigration reform. Some of the issues that we'll be discussing on Lobby Day also deal with our access to the vote. As we talked about, Asian Americans are a growing segment of not only the national demography, but are also a growing segment of the electorate. The unfortunate reality is that when racial and ethnic minorities increase in their political participation and their political activity, a countervailing force applies to try to disenfranchise Asian American voters. And so working together, we've been able to work on issues to make sure that Asian Americans can fully exercise their right to vote. The biggest issue that's happening right now is Section 5 of the Voting Rights Act. The Voting Rights Act is probably the most successful piece of federal legislation enacted from the Civil Rights era. Unfortunately, it has eliminated many voting barriers to votes that have been levied against African Americans, Latinos, Asian Americans, and Native Americans. The Voting Rights Act includes provisions for bilingual ballots. And yet jurisdictions have still complained about the Voting Rights Act Section 5, which covers particular jurisdictions that have a history of voting discrimination. Shelby County, Alabama, brought a suit against the federal government challenging the constitutionality of the Federal Voting Rights Act, and the Supreme Court had held oral arguments on that a while back. ALDEF is proud to work with the AHJC to lead the effort in developing a national response for Asian Americans on why the Voting Rights Act and Section 5 enforcement is particularly important Currently, ALDEF represents voters in New York, Georgia, and Texas, all jurisdictions which are covered under Section 5. And under Section 5, jurisdictions that have a history of discrimination must pre-clear voting changes, and the jurisdiction must prove that those changes do not have the purpose or the effect of discriminating against minority voters. I was just in a briefing in a voting rights litigators meeting in Washington, D.C. Yesterday, and my colleagues in the voting rights bar work together and are trying to figure out what is our response to should the Supreme Court make various types of decisions regarding the Voting Rights Act. Many of our friends on Capitol Hill are very interested in what the civil rights community has to say. And so the message that we are asking people who go on the Hill to say when they ask about the Voting Rights Act, and what is the congressional fix? Does Congress have the legal authority to regulate elections and to, under the 14th Amendment of the United States, prohibit forms of racial discrimination in voting? Or is the Supreme Court going to say that Congress is inept at doing that Congress does not have the power to prevent racial discrimination in the voting context? That would be an incredibly a significant decision that they would make. The Supreme Court has said 4 times over 4 decades that the Voting Rights Act is constitutional, but we have concerns in this election and in this term. And so many of our friends in Congress are asking, what is the message? We in the civil rights community and in the voting rights bar are working on a message and are working on a fix should the worst come about. We are actually talking with our friends on the Hill, but what you just need to tell members is that we are monitoring the Supreme Court with the Voting Rights Act. Our civil rights lawyers will be working with voting rights lawyers from the African American Latino community. We are not entertaining any fixes to the legislation. No fix should not be done without bipartisan support. So if a member has a bill, they should only introduce that bill with the support of a Republican and with the support of the civil rights community. It will be difficult, but it will be our action to oppose bills that are only by one party or by one member. And so we hope to have a resolution by June, and we will come to Congress and we will talk about these proposals. But right now, if they ask about what you're feeling about the Voting Rights Act, it's important to understand that the Voting Rights Act has, in the past, protected Asian American voters in voting. It has ensured that language assistance plans in New York can be fully implemented. It has ensured the continued election of Asian American candidates in the state of Texas. And so we were happy to participate in that. And so the message is we are working on the Voting Rights Act, and we will get back to you then. But there's a lot of anxiety and interest on the Voting Rights Act on Capitol Hill. Our lobbyists are getting called every day on that. On the next slide are other provisions that are there, and I'm going to talk about 3 other bills in which NAPABA is supporting to allow remedies in the voting process. One is the Cardin-Schumer Deceptive Practices and Voter Intimidation Prevention Act. And this bill would prevent deceptive practices. So if a candidate went around and posted signs in a minority neighborhood that said, Election Day has been moved to Wednesday. Election Day is never moved to Wednesday. It's always on Tuesday. Or if robocalls go out and say, a survey comes on the telephone saying, fill out this new ballot. You can vote online. And most places don't allow online voting. Intentional misrepresentations to disenfranchise a minority group from voting. A comment or a flyer that says immigration service agents will be posted at poll sites on Election Day. Things that are intentionally designed to depress minority voting patterns are currently legal. They may be unfair, they may be inappropriate, but they are not outside of the bounds of the law. We believe that intentional misrepresentation and lies that mislead a minority community is improper, and the Cardin-Schumer Deceptive Practices bill does eliminate and makes it improper to engage in such willful misrepresentations in the voting process. And so we're hoping that individuals can support that piece of legislation. We do think that lies and misrepresentations are improper. And then the next slide are two other provisions, the Voter Access Prevention Act, which allows for greater access to voting and prohibits election officials from requiring photo identification. ALDEF is proud to be working with NAPABA, Pennsylvania, for example, on the Applewhite case. Pennsylvania's new law that was enacted that requires photo identification in voting, restricting the access of Pennsylvania voters to be able to exercise their right to vote. And so that matter is actually coming up for litigation this summer, and ALDEF and NAPABA PA are proud to work together to bring the Asian American experiences to both the trial court and to the Supreme Court for the Commonwealth of Pennsylvania. The Voter Access Prevention Act will allow, next slide please. The Voter Access Protection Act will allow for greater access to voting and prohibit forms of photo identification. 5 states right now require that all voters have to provide documentary proof of U.S. citizenship, and the effect of that is that foreign-born voters have to bring their original naturalization certificate or mail a copy of their passport to the voter registrar. Hopefully it'll come back, and that's how you register. But if you're a U.S.-born citizen, that's fine. You can just send a copy of your birth certificate. Most Asian American voters aren't going to take that time and trouble or the risk to mail their passport or to mail their original naturalization certificate or even go to the voter registrar to register to vote. And so this bill would actually allow those 5 states, Georgia, Kansas, Arizona, and that's actually in litigation right now, Alabama and Tennessee, from requiring voters to have to prove United States citizenship in an unfair and different way than United States native-born citizens. And the other provision is the Voter Empowerment Act on the next slide. The VEA is a very powerful piece of legislation. It's a very long piece of legislation that modernizes voter registration system, decreases barriers. Our civil rights lawyers and voting rights attorneys looked at every decision by the United States Supreme Court that was adverse in the voting process. Statements that said English-only laws are improper in the voting context, regressive voter identification, voter caging, misrepresentations in voting, all the improper shenanigans that is really made to disenfranchise minority voters. We looked at all of those laws over the past 20 years, and we all put them into a very big bill called the Voter Empowerment Act. The problem with the Voter Empowerment Act is that it's only a Democratic-led bill. We do not have a Republican sponsor. And so we are hoping that Republicans in the House and or the Senate will agree to co-sponsor the Voter Empowerment Act to make sure that voting is a much more fair system for all Americans in the United States. We are so happy at ALDEF to work with not only NAPABA PA, but NAPABA DC in a number of poll monitoring efforts, SABA, the South Asian Bar Association, ABA Texas, and a number of affiliates to make sure that when problems occur on Election Day, that those issues are brought to the fore and that we can encourage an investigation by the Justice Department or that we can do our own investigation. These laws, the Voter Empowerment Act, the Voter Access Protection Act, Deceptive Practices, and Section 5 of the Voting Rights Act, give our lawyers in the Asian American community the ability to bring lawsuits and threaten lawsuits against elections officials so that all Asian American voters can fully exercise their right to vote and exercise their right to vote on a bilingual ballot. Thank you. For more information, contact me. There's my information.
Thank you, Glenn. Yes, his contact information is right there if you'd like to contact him. I'd like to thank Glenn for his presentation, and I'd also like to reintroduce our final presenter, Emily Chatterjee. Emily Chatterjee serves as Policy Director for NAPABA. Her responsibilities include leading and developing NAPABA's policy and advocacy work on a wide range of issues, including judicial nominations and immigration reform. Emily will now discuss judicial nominations.
Thanks, Melanie. And so our last policy priority for NAPABA Lobby Day this year is federal judicial nominations. As the first slide notes, there are currently 19 active APA Article III judges out of approximately 875 authorized Article III judges. Next slide, please. So that's a really small slice of the pie, but there has been tremendous progress since the beginning of the Obama administration. At that time, there were only 8 active APA Article III judges. Today, there are 19 APA Article III judges. Most recently, Pam Chen was confirmed to the Eastern District of New York. She is the first LGBT APA judge in U.S. history. And Derek Kahala-Watson has just recently been confirmed to the District of Hawaii, and he is currently the only Native Hawaiian on the entire federal bench. There are currently, as I said, 17 district APA Article III judges and 2 appellate APA judges nationally. So where are we now? There are 2 APA nominees currently awaiting votes in the Senate Judiciary Committee. First, we have Sri Srinivasan, who is nominated to the U.S. Court of Appeals for the D.C. Circuit, and Sri will likely have his vote from the Senate Judiciary Committee on May 16th, and we would very much like to get him confirmed to the D.C. Circuit during APA Heritage Month, which would be a major milestone for our community. So that is one thing that we would like everyone to be talking to their senators about. This is only relevant on the Senate side. And then Ray Chen, who has been nominated to the U.S. Court of Appeals for the Federal Circuit. Ray, if confirmed, will be the first APA to sit on the Federal Circuit in more than 25 years. And we expect that he would be voted out of the Senate Judiciary Committee in early summer, most likely. As I said, we have achieved a lot in the past few years working with the Obama administration and with senators who have been very supportive about promoting well-qualified and diverse nominees. But there's a lot more work that remains to be done. Last year, we had another milestone during APA Heritage Month when Jacqueline Wen was confirmed to the Ninth Circuit. She was the first female APA appellate judge in U.S. history. Likewise, this year, if Sri Srinivasan is confirmed during APA Heritage Month, he will be the first South Asian American federal appellate court judge confirmed in U.S. history. One other point that I think is important to note, particularly for folks coming from, I guess, more non-standard APA states, is that our judges tend to be clustered in particular states. We have a lot of judges in California, Hawaii, now 2 in Illinois, 2 in New York. But there are a lot of states where there has never been an APA federal judge. And if you are meeting with your home state senator and you are from a state that has never had an APA judge, it would be wonderful to first encourage them to nominate well-qualified, diverse candidates, and then also to ask about their process. Do they have a commission? Who do they look to for advice about what names they should put forward to the White House? And ask how you can help, how you can get involved in this process, because we need folks to be serving on these commissions and to be involved in the process of getting forward these names, because we need, one of the things that NAPABA has done such great work on is creating this pipeline to put forward well-qualified, diverse nominees. So our last slide illustrates what our goal really is, which is if the number of judges on the federal bench actually approximated what our population was, there would be approximately 11 to 12 APA federal appellate court judges. We currently have 2, and 40 to 41 APA federal district court judges, 2017. So there's a lot more work for us to do, and we've achieved a lot, but thank you so much for supporting this work and for talking about this during your meetings in May.
Thank you, Emily. We'll now hear from a couple of questions submitted. So the first question is, what do I do if I'm in a meeting and asked a question I don't know the answer to?
This is Emily. If there's a question you don't know the answer to it, you say, I'm sorry, I don't know the answer to that, but I'm happy to follow up and we will get that information to you. And take down make sure you have the contact information for the staffer. We should have it, but get their card and we will absolutely follow up with them.
And this is Tina. That's exactly the kind of thing that you should remember to bring up in the debriefing, and one of the reasons why we have the debriefing, so that we can find out from you what happened in the meeting and what kind of follow-up we need to do.
Great, thank you. The next question is, are we meeting mostly with Democrats?
This is Emily again. No, we actually have a very diverse set of meetings. In fact, I think we would say more than 50% of our meetings are with actually Senate and House Republicans. In fact, I think one of the things that we're looking at is to have more meetings, particularly with House Republicans, because that is sort of where we need to have some conversation, particularly when it comes with regard to common sense immigration reform.
And this is Tina. I'll just add that you should remember that NAPABA is not a partisan organization. We're a nonpartisan organization. So as you go into these meetings, keep that in mind, that each of us has our own advocacy agendas, whether personally or with other organizations we might be affiliated with. But in terms of this particular lobby day, you really need to put on your NAPABA hat, and part of that is being nonpartisan.
Thank you. The next question is, in urging diversification of the federal bench, how do we best combat the argument that diversity equates with a lowering of standards and quality?
I would say that all of the folks that we are supporting are extremely well qualified, first and foremost, and that no one that we have supported or are supporting is someone who we're supporting because they are Asian Pacific American. And I think their qualifications speak for themselves, and I would certainly say that's true for both Sri Srinivasan and for Ray Chen.
Right. Thank you. The next question. There are a lot of intricacies to all these bills and issues. Is it okay if I need to read off my notes during the meeting? And I can answer that. I think that it's important to bring your notes. You can read them throughout the meeting. I think all of us on staff were at meetings last year, and we did that, and none of the staffers or members of Congress thought any less of that. And they do have an expectation that, you're not an expert in the policy issue, and it's totally okay.
This is Emily. I would say, though, that it might be helpful, particularly during the training on May 20th, the day before we go into meetings, to talk with your group and to talk through sort of the issues that you're going to prioritize and split things up so that no one person has to sort of be the conveyor of everything, and so that, you have a mastery of, your sort of discrete part to the extent you can, because you want it to be a conversation with the folks you're meeting with.
Right. And this, I'll just add that I think Emily's point that it be a conversation is an excellent one. Remember, no one expects that you're going to be an expert in any of these areas, but they value hearing from constituents and hearing from people who have real-life experiences. So don't be afraid to say that you don't know the answer. Don't be afraid to go to your notes if you need to. But also remember that what is really going to resonate with staffers and with members is hearing how this has impacted your life, your family's lives, family members' lives, and people you know.
Great, thank you. The next question is, how big will the group meetings be? Will the group leader do the majority of speaking? So I can answer this first off. The groups are going to be approximately 3 to 5 members. You'll have a team leader for every group. However, the group leader doesn't necessarily need to do the majority of the speaking and may not in a variety of scenarios. The team leader is primarily responsible for making sure the group arrives at the location at the same time, for debriefing everyone before and after the meeting and helping the group to prepare. But everyone in the group should take an active role in the meetings. There may be some meetings where you have a particular expertise in the issue, and you may want to discuss that. Then we have another question. I have family members who are undocumented. Is it safe to disclose this information to emphasize the real human aspect of the issue?
Absolutely. No question.
And a follow-up question that we have on that is, Should I tell my immigration story when I discuss comprehensive immigration reform?
If it's relevant, absolutely. That is exactly what you should be talking about. The more concrete face that you can put on these issues, the better. And the same thing goes for voting rights. And, you know, if you happen to have represented someone to the extent that it's, you know, kosher to be talking about the representation in immigration proceeding or in voting, like, that also is relevant. And the more you can tie it to, you know, your home state and your district, even better.
So let me add to that. This is Glenn Mapanta. I teach a class on the legislative process. As lawyers, I think we are trained to and taught that knowing the arguments and the arguments of the other side and making our arguments is what carries the day. And in court, that is probably true. You are not in court. You are in Congress. You are in a coordinate branch of government where your arguments, frankly, don't matter that much, or your knowledge of the other arguments doesn't matter that much. What matters is your story and your biased opinions. Your presence as a constituent and as an active member of the community who's involved in your bar association, because you know what? Your story and your interaction with a member of Congress and a staffer will get out to other people in the district. Will get out to other people who may or may not vote. So it is more of a political process, and it is what you say and how much you bring that is more important here. And so keep that in the back of your mind and as you engage in Lobby Day.
Great, thank you. We have one more question. Are we using the term common sense immigration reform or comprehensive? Please explain the importance of the terminology.
Jessica, do you want to talk about that?
Hi, this is Erin. Sorry, I can speak to that. I think that the preferred term this time around is common sense immigration reform. You know, I think that people have felt that there was, you know, sort of baggage tied to the term comprehensive immigration reform, which is something that has been promoted for a long time now. So the idea was to sort of change the framing of the issue to say that this is common sense. Our system is broken and we need to fix it, and we need a solution that, you know, does its best to get at the interests of everybody who's interested in reforming our system, to have common sense, practical, reasonable solutions to a broken system.
Thank you. That looks like all the questions that we have for today. So I'm going to thank our presenters once again and turn it back over to NAPABA Executive Director Tina Matsuoka.
Thanks, Melanie. You did a great job coordinating this webinar. And I just want to thank everyone, all the participants who called in. I know your time is valuable, and we appreciate that you spent an hour with us. A special thanks to our guest presenters, Erin and Jessica from AAJC and Glenn from ALDEF. You know, we appreciate your time here today, and we also want to acknowledge that you've been great supporters and friends of NAPABA, and it's not just this hour you've given to us, but a lot of time over the years. We look forward to seeing you all during Lobby Day. The next time we'll see you is May 20th at the Lobby Day training and the congressional reception that will follow immediately thereafter. You will be receiving additional materials by email prior to the next training, so please be on the lookout for those and try to review those documents in advance of our next meeting. If you have any questions in the meantime, you can please feel free to contact Melanie. Her information is up on the screen, and I think most of you have it already because she's been in touch with you. That concludes our webinar today, so thank you again and enjoy the rest of your day.